This is an all points bulletin to make sure you check on your local gun controlling neighbors, acolytes, friends, and family members because it turns out even the Ninth Circuit can't abide by 1 in 30 purchase limits. Yep. This is bigger than just the Ninth Circuit's decision that just dropped, basically annihilating purchase limits in a 30-day time span. Guys, you are winning. You are finding the line. They are figuring out. They've FAFO'd, and now I'm going to walk you through the entire thing. Everything will be linked in the description box below. I cannot wait to hear what you guys think, and of course, make sure you hit that like button. Subscribe to the channel. Turn the notification bell on every single time that you do. There's a paper cut involved with your most recent gun control interaction, and Lemon Juice finds that immediately. All right, listen, let's get into this, guys. Forgive me, I am still getting over this cold. It really kicked me right in the face, but that cannot stop this freedom train. All right. At Braden LOA, that's where all this stuff is available. Let's dive right in. This might be a shorter video, but it's a big one. So an FPC legal update. The Ninth Circuit. Now, the Ninth Circuit, that's like Leftyville, okay? That's like anything goes when it comes to gun control. Almost anything goes. They can't even get 1 in 30 purchase bans through this judicial branch, this circuit. The Ninth Circuit has issued its mandate in our win against California's 1 gun per month law, making this the first time the court has issued a final judgment striking down a law on Second Amendment grounds. The first time that the final judgment comes down on grounds to support the Second Amendment in the Ninth Circuit. This is why this is such a big story. I'm going to walk you through the entire thing, all the details. This is why this is such a big deal. Because they have pushed in California, in Washington, all the far left bastions of gun control. They have pushed further and further and further, and they've gone as far as they want to go until that court finally meets the point where it's breaking point. They say, I cannot go any further because you're being that crazy. 1 in 30 limiting bans of when you can buy a gun 1 in 30 days is patently unconstitutional. They know it, we know it, everyone knows it, and the Ninth Circuit just admitted it. The bottom line on this, guys, they just found the breaking point. I did a short on this earlier. That line where you're holding and you've got an entire battle line and they don't move forward anymore, that's because they can't. They can't move forward anymore because it's that egregiously offensive to the Second Amendment and the Constitution. So now they've found that line, that breaking point of resistance. It stopped breaking. That's what's happening right now. So now they can't go beyond this because they just found the breaking point. So they're now going to start working their way backward to find the other side of that breaking point. You're working to establish a narrow field of where this is too little, this is too much. They are working into this room. It's basically equilibrium in a judicial sense, okay? The concept of equilibrium in economics. The idea is you're not going to go too far because it can't be supported. You're not going to go too shallow because it can't be supported. So you're going to find happy ground right there in that middle. That's what's happening right now on the judicial side. The left has taken advantage of the Ninth Circuit for far too long. The exact opposite thing is happening in the Fifth Circuit. They go too far from the left perspective. They go too far. They kind of meet that line and they start backing off a little bit, and then they find it the other side as well. You're finding equilibrium in the court systems. That's what's happening. In fact, they tear this asunder when they reference the Braden decision in this. Listen to this. So this is the Wynn versus Bonta challenge to California's 1 in 30 firearm purchase ban. This is an FPC lawsuit. Sorry, seriously, guys, I'm sorry. My voice sounds real weird. Federal Second Amendment constitutional challenge to California's ban on purchasing more than one handgun or semi-automatic centerfire rifle in 30-day period. Now, it's obvious this is unconstitutional, but let me show you the actual opinion. It's right here. I've got it pulled up for you. This right here, this is a very key, important point. I'm going to highlight and zoom in. Here. This is from the original opinion that the Ninth Circuit just affirmed. I'm going to show you that in a second. The Second Amendment expressly protects the right to possess multiple arms. It also protects against meaningful constraints on the right to acquire arms, because otherwise the right to keep and bear would be hollow. And while Braden does not require a historical twin for a modern firearm regulation to pass muster, here the historical record does not even establish a historical cousin for California's one gun a month law, affirmed. That's the whole point. The Braden decision is now cycling through the judicial. It's been 3 years now. You're looking at exactly where we need to be. We're pointing, it's not only a historical twin, it's not even a historical cousin, as they just said in this ruling, okay? That's what happened. That's what they were trying to get an en banc affirm for it, but they just denied it. This is the final thing for the Ninth Circuit. This is the ultimate culmination. The judgment of this court, entered June 20, 2025, takes effect this date. This constitutes the formal mandate of this court issued pursuant to Rule 41 of the Federal Rules of Appellate Procedure for the court. This takes effect this date. That means it cannot be allowed. Guys, here's the bottom line. The fight in which we're in is a big, broad, massive fight. It's not just one kill it, one headshot done to the zombie. This is going to be a long, extended fight. We're here for it. It's what we do. But what you're talking about right now in the Ninth Circuit, where they can't even find a, quote, historical cousin for the gun control laws, they're striking him down before they even get to SCOTUS in the far left bastions of the Ninth Circuit Court. Guys, this is an important moment. The 1 in 30 is now gone. The one gun in 30 days, completely toast. The Ninth Circuit has even found a point where they cannot bend the interpretation to get to that. And that's what I've got for you guys. It was a shorter video. Sorry, I feel like crap, so I hope this got this delivered and landed that plane. And I will see you on the next one. I'm Braden. See you there.